Officer Dave, you open the courtroom for us, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. I don't have anybody here. Let's go to iPhone, see who it is. Morning.
Good morning, Your Honor.
What brings you here today?
I am here on Ford Credit versus Rashida Parker, last 3-330.
I have Rashida Parker.
Okay, great.
Can't get started. Hello? She's still connecting the audio. Hello? No audio. Hello? Hello? I'm going to put her back in the waiting room and try to bring her out. Sometimes that makes the audio work.
Okay.
Let's try it again. I still don't have audio. No audio. There we go. I think we got it now.
All right.
Hello, can you hear me?
Yes, now I can.
Okay, I'm sorry about that.
We are on the record calling 10102-330 Ford Motor Credit versus Rashida Parker. Date and time for objection to garnishment. Your appearances.
Good morning, Your Honor. Robin Stradowski on behalf of Ford Motor Credit Company, P number 71195.
And what is your name, ma'am?
Rashida Parker.
You are the moving party. What is the basis of your objection to garnishment?
I've never had a driver's license and I was never in possession of the car. My father was in possession of the car.
Do you have any other basis for your objection to garnishment?
Him and Albert Taylor, that's
Him and Albert Taylor worked for Ford, and
they had nothing to do with you. You
but-
were only 19
Excuse
years.
me.
I was only 19.
If you want to tell me something, you can. If that person in the background is not a lawyer, licensed to practice law in the state of Michigan, then they need to be quiet. Please continue, ma'am.
I was never in possession of the car. My father was in possession of the car. He got the car for me, and he drove me around. He got upset with me and took the car back. I've never driven a car. I've never driven a car. I have no driver's license, never had a driver's license. When the car was supposedly in my name, I had a job, but I wasn't even making enough to make car payments or anything. I don't know what Albert Taylor and my father and them put on the papers, but I never signed anything for this garnishment or anything like that. I've been my state taxes have been garnished for the last 10 years, and I didn't want to get my father in trouble, so I didn't say anything. My father has recently passed away, and if you check my record, I have no driving history, period, whatsoever.
Okay, let me hear from Ms. Drozowski.
Thank you, Your Honor. It appears that Ms. Parker is attacking the underlying judgment, which is not a valid objection to a garnishment. A judgment was entered in this case April 26, 2010, after Ms. Parker was personally served and did not respond to the lawsuit. The judgment was renewed on December 9th, 2019. There still is a valid judgment in this case, and there is a remaining balance on this file. As Ms. Parker said, we have been receiving tax garnishment money. I'm not sure why this is the first time she has brought this objection to the court. But like I said, this is not a valid objection to the garnishment. We ask that her objection be denied. We will work out some kind of payment arrangement with her, but for the purposes of today, we ask that the objection is denied.
All right, the only matter before me today is the objection to garnishment. Ma'am, Michigan Court Rule 3.101K specifically provides that you may not use the objection to garnishment as a method of attacking the underlying judgment. And just for the record, to flesh out the record, although it's not relevant because you can't do what you're attempting to do, the file indicates that on February 4th, 2010, you were personally served with summons and complaint at the same address that you use on your objection to garnishment. Further, on April 26, 2010, when you failed to answer, the matter went down to judgment by default. That judgment by default was renewed back in December of 2019. Further, attached to the complaint, ma'am, is a copy of the sales agreement in relationship to the vehicle. There are two names on there. One of the names, and with two signatures, is Rashida Parker. Having failed to state a valid objection to garnishment, your objection to garnishment must be denied. Ma'am, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. The court will send out an order to you both. Thank you both for coming in. We are off the record.
Thank you, Your Honor.
Have a good day.
Thanks, you too.
Gateway Financial, Chico, okay. Admit. Admit. 285. Also, good morning. I'm waiting for your opponent to connect the audio.
Good morning.
Sometimes it takes some time. Did not connect. I'll put her back in the waiting room and try to bring her out again. Let's try it again. Hello? Oh, it's connecting, maybe. Yeah, we got it. Hello.
Can you hear me?
Now I can.
Oh, I'm sorry.
This is file number 21-171-285. The file is entitled Gateway Financial Solutions versus Candace Chico. Date and time for objection to garnishment. Could I have your appearances?
Yes, good morning, Your Honor. Zachary Schisler, P number 82247, appearing on behalf of Gateway Financial.
And what is your name, ma'am?
Candace Chico.
You are the moving party, Ms. Chico. What is the basis of your objection to garnishment?
Well, for one, I'm homeless, and then for two, I'm trying to surface to get a place to stay, and I can't afford for any garnishments.
Do you have any other basis for your objection to garnishment?
Other than I'm dealing with hardship.
Okay. Mr. Schisler.
Your Honor, I'm sympathetic to the situation, but that is not a valid objection to garnishment under Michigan law. So I would ask the court to deny her objections or rule them invalid. But I would also like to give Ms. Chico my direct dial and see if we might be able to work something out amongst ourselves after today's hearing.
All right, I'm going to do two things. First of all, Ms. Chico, financial hardship, while something we all recognize is real, is not a valid basis for an objection to garnishment. Your objection to garnishment must therefore be denied. What I'm going to do is I'm going to put you two into a chat room to see if you can work something out. If you can, then submit whatever paperwork is necessary. In any event, I'm going to send out today an order denying the objection to garnishment. You will have 21 days to perfect your appeal in the Wayne County Circuit Court. Let me get y'all into a chat room if I can make the technology work today.
Thank you, Your Honor.
Room 4. Okay. Got that one done. Let's try this George. I don't have a George. Let's see who that is. Hello?
Hello, hello,
What is your name?
Latanya Tolliver.
That's not the name that's displaying on the screen, ma'am.
Oh, Latanya George.
Let's get you up here and get started.
Okay, good morning.
Good morning. Good morning, counsel.
That's it.
Good morning, Your Honor. Jay Lazar on behalf of plaintiff, P69480.
Let's call the case first.
Oh, sorry.
This is file 17114-969, Pioneer Finance LLC versus Latanya Tolliver. Now let's have your appearances.
Apologies, Your Honor. I hit a little sound glitch there. Good morning. Jay Lazar on behalf of the plaintiff, P69480.
And your name, ma'am?
Hello, can you hear me?
Yes, what is your name again?
Latanya Tolliver.
You are the moving party. What is the basis of your objection to garnishment?
Well, I didn't even know that I had a garnishment, and I got I didn't even know I had a garnishment. This whole thing has been a disaster since I purchased this furniture from my father. I don't even have this bedroom outfit anymore. I paid for this thing. There were issues with it from the very beginning. I moved and I didn't even receive the information for the court. And I had forwarded my email, my address. I don't know why they took it to the old address. But anyway, to go back to the original furniture, that furniture was returned to them. And it was over years. I bought that furniture from my dad, and that furniture was returned to them. I had issues and issues and issues and issues with them. And I thought that this was resolved. No one ever called me. I thought this was resolved. They still owe me money. I don't owe them anything. That furniture was horrible. And it was returned back to them. When it was returned, it was a long process with Art Van over and over again. First they said that it wasn't here. They were going to refund me. Then they never refunded any of my money at all, ever. And then they said that they were going to take this off. And I got a letter from, and I got it confused. I thought it was Progressive, it's Pioneer Leasing, but I got a letter from them. And when I moved into this new place, my place flooded. But I had a letter from them and from Art Van. And there's no reason that the court should have garnished me. I was there. They had a way to contact me. They shouldn't have garnished. I can't handle this.
Counsel, let me hear from you.
Your Honor, this has all been dealt with previously. My client is Pioneer. It's not Art Van. We financed it. So the furniture, unfortunately, similar to like a car purchase where you pay the bank, is a similar analogy. But my client, it's a signed financing loan she asked for. They provided their part. But we're here today for an objection to garnishment. The judgment's been held bail. We've already dealt with all that. Previous filings on her behalf show that she was well aware of it. She's been tax garned in 2020, almost $1,500, which was credited to her account. We're well past notice. We're well past all that. There's been no veiled objection. In fact, from what she said, unfortunately, and I'm just doing my job, ma'am, I see you there. The fact is she just admitted the notice on top of everything, and that the employer properly gave her the information of the garnishment, because that is how the garnishment is notified. So there is no veiled objection, and plaintiff does ask that the objection to the garnishment be denied, Your Honor.
All right.
I didn't get the garnishment until the other day. I had no idea about it.
All right, ma'am, thank you. I'm prepared to rule. I think there's something that you need to understand that you apparently do not. Let me first go over the procedural history of this case. The idea that you had no notice here, ma'am, is belied by the fact that after summons and complaint was served by alternate service, you filed an answer on October 4th of 2017. It appears that thereafter, the matter went forward to a dismissal for lack of progress. A motion was filed to set aside the dismissal. Notice was sent to you at the address that the court had for you. You failed to appear for that notice. The motion was granted. The court set the matter for pretrial. That pretrial was set on April 6, 2018. The judgment was entered on that date because you failed to appear.
I wasn't living there. I'm sorry.
It was at the address that you had on file with the court. Now, if you hadn't changed the address, ma'am, that's on you. In regard to the way garnishments work, once there is a valid judgment against you, the plaintiff does not come to you to garnish you. They go to a bank, they go to a credit union, they go to an employer, and they file a writ of garnishment. That writ of garnishment requires the garnishee defendant, that is the entity receiving the writ of garnishment, to do several things. One, they must file what's called a disclosure. Well, they say, yes, I have this money that belongs to Ms. Tolliver, or no, I do not have money to that belongs to Ms. Tolliver. It is the obligation of the garnishee defendant, not the obligation of the plaintiff, ma'am, to let you know that you have been garnished. Having failed to state a valid objection to garnishment, your objection to garnishment must be denied. You, of course, have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. In addition to the request for installment, objection to garnishment, there's a request for installment payments. Mr. Lazar, what's the present value outstanding on the debt?
Give me one moment. Let me get the exact number, Your Honor. Your Honor, the current balance is $4,573.03.
What is the interest rate?
The judgment interest was 13%, Your Honor.
13%, $4,000. So okay, I got it. The requested money here is $100 a month. So roughly the interest is roughly $40 a month. So she'd be making roughly $60 a month in payments. The court is going to grant the requested order for installment payments. Each of you will get 2 separate orders. What is it, ma'am?
I have to pay more interest on this?
Ma'am, you pay interest on the judgment until it is satisfied. It's like a credit card. The court will enter 2 separate orders. There'll be an order denying the objection to garnishment. There'll be an order granting the motion for installment payments with installment payments of $100 a month to start on May 23rd. May 1st, 2023. Anyone who disagrees with my decision has an absolute right to appeal. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. What is it, ma'am?
There were deductions taken out of my last 2 paychecks. What happens with that? Do they go towards the balance?
Correct, ma'am.
So if $1,000 was taken off,
Then your balance has been reduced by $1,000 minus, and emphasize on this, minus the cost of the interest and any attorney costs and costs, for example, of the garnishment. You are paying at a $4,000 balance. You're paying about $40 and change, maybe closer to $44 a month in interest only. So if you paid $1,000, roughly 955 or 960 of it would have gone on the balance. The balance would have gone to the interest that you were paying. We'll send out 2 orders to you today. Thank you both for coming in. We are off the record.
Thank you, Your Honor. Have a great afternoon.
All right. Y'all be safe.
Be safe.
Good morning, counsel.
Yes, Your Honor. I was able to work something out with Ms. Chico. So I was just going to ask which way you'd rather have me submit the order. So I know you mentioned that you were going to submit an order denying her objections.
Yeah.
We're going to reduce the garnishment withholdings to 75 biweekly.
Then send in an order to that regard.
Under the 7-day rule?
Yes, sir.
All right, that works. That's
Well,
what
actually, no, you can't do it under the 7-day rule. She has to sign it. She has to make it
stipulated work.
Yep.
We'll do that.
Thank you.
Thank you.
Appreciate your time.
Yes.
Hello?
Hello, how you doing?
What is your name?
Cornisha James Williams.
So I'm looking for Mr. Babcock. All right, we are on the record. This is 17108-039 Oakwood Health Systems versus Cornisha James Williams. Date and time for objection and garnishment. Your appearances.
Your Honor, Harvey Babcock on behalf of Oakwood.
You remember the State Bar of Michigan?
I am a P23718.
And your name, ma'am? You have to unmute.
Cornisha James Williams.
You are the moving party. What is the basis of your objection and garnishment?
Have hardships. I don't understand why they're still garnishing. The garnishing expired in 2020 that they're garnishing from.
Do you have any other basis for your objection and garnishment?
Yes, I don't have a job. I'm in school. I just had a baby. I don't have money for them to garnish. I'm on my own.
Let me hear from Mr. Babcock.
Your Honor, I'm sorry, I did not understand what she said. She's kind of muted.
I said I am a single mom, which I'm here now with my child. I don't have the money for you guys to garnish it. I'm on my own. I'm just a full-time student. I'm barely making it. So for you to garnish it, and the garnish expired in 2020 that you're garnishing from.
All right, Mr. Babcock.
Your Honor, that's not a defense to a garnishment. That's also not what she wrote. The fact that she can't afford it, she's had.
I can't afford it, and I was never served the
Ma'am, I
garnishment.
didn't
It
mean
says
to
the
interrupt.
address.
Excuse me, ma'am. It
I
said,
was-
just like you were able to speak without interruption, he can speak without interruption. Mr. Babcock, if you start again, sir.
Thank you, Your Honor. What she's indicated is not a defense to a garnishment. The judgment that Your Honor entered in this case was back in July of 17. She's had 6 years to try to work this out. She's paid absolutely zero other than the garnishment monies we have received, and every time we've garnished her, she's filed an objection. So the bottom line is, Judge, it's not a valid defense.
I
Ma'am,
was
go ahead, please continue.
I was never served the garnishment that you guys sent. That's not my address. For the last 5 years, I've been had an address. So I was never served and was never noticed. And the garnishment that you're replying to was expired in 2020. And I've been a student for the last 6 years trying to a thing. And I just have a child. So there's no way that I can afford to do anything.
All right, thank you. The court is prepared to rule in this matter. First of all, ma'am, you were personally served with summons and complaint in this matter on April 15th of 2017. You failed to respond to answer, and I know for the record, you were served at the same address that you used on your pleading today. You failed to respond, and on July 5th, 2017, judgment by default was entered against you. That judgment, ma'am, lives for 10 years. 10 years from 2017 is 2027. This is 2023. The judgment is still alive. Having failed to state a valid objection to garnishment, your objection to garnishment must be denied. I should explain one more thing to you about the garnishment proceeding. Once a plaintiff has a judgment against you, they don't come to you for writ of garnishment. Instead, they go to a bank, they go to employer, they go to the state of Michigan and file a writ of garnishment. The person or the entity receiving the writ of garnishment is now called the garnishee defendant. The garnishee defendant has several obligations. The first one of which is to say, yes, I have money that belongs to the defendant, or no, I do not, in writing. That in writing disclosure must be served on the garnishing party. It is also the obligation of the garnishee defendant, not the plaintiff, to advise you that in fact you have been garnished. Having failed to state a valid objection to garnishment is denied.
Sorry, I would
Excuse me,
like
man,
to.
don't interrupt me. You got a bad problem here. This ain't a TV show.
You have been rude from the beginning, sir. So you have a bad.
Thank you, ma'am. We're done. Having failed to state a valid objection to garnishment, your objection to garnishment will be denied. You have an absolute right, ma'am, to appeal my decision, and appeal will be perfected within 21 days of today in the Wayne County Circuit Court. Thank you for coming in. We're off the record.
Your Honor, can you get back on the record? I have a question, or I have a request for cost.
I'm not going to order costs this time, Mr. Baker.
Okay, that's fine. All right, that's fine, Judge. Thank you. Do you have the order, or should I submit an order?
I had the 2 orders. Thank you.
Okay, thank you, Judge. I'll wait for your order. Have a
They'll
fun
go out today.
afternoon.
Hello? Hello?
Yes,
What is your
Mhm.
name?
my name is Jasmine Wright.
Jasmine Wright?
Yes, sir.
Okay, hang on. Mr. Kuipers, good morning. Hello?
Sorry, Your Honor, I'm stuck in another courtroom with Judge Rob
Back to the
Coleman.
waiting room.
Oh, thank you, Judge.
Ms. Wright, I'm gonna have to put you back in the waiting room. Counsel's on another hearing on another courtroom.
Okay.
Put you back in the waiting room, ma'am. You ready for me now, Mr. Corpus?
Yes, I am, Your Honor. My apologies.
Ms. Wright, I think we have ourselves all set now. Let's call your case. This is file number 1918159, Sun Home Services Incorporated versus Jasmine Wright. Date and time for objection garnishment, your appearance.
Good morning, Your Honor. Matthew Kuipers on behalf of the plaintiff, P71348.
And what is your name, ma'am?
My name is Jasmine Wright.
Ma'am, what is the basis of your objection to garnishment?
So the basis of the adjustment garnishment is because of the fact, when this debt was occurred, that money was given to the plaintiff that is on the document also, and on the secondary person on the document.
The plaintiff is Sun Homes.
I'm sorry, the defendant, Desmond Flagg, that money was given to him and I moved from the premises and I had no other dealings with him.
But you co-signed.
Yes, sir.
Do you
But
have-
they're taking,
do you have
they're
any other
taking,
basis, ma'am, for your objection to garnishment? You co-signed the note.
I understand that, but what I'm saying is that the money was given to him to pay the note. I didn't know anything about this till they started garnishing my check.
Well, ma'am, is there anything else you want to tell the court?
No, sir.
Mr. Corpus,
Your Honor, I'd note that under MCR 3.101K, the defendant would need to show some defect or irregularity in the actual garnishment itself and cannot attack the underlying judgment here. I'm not hearing that, so for that reason, I'd ask the judgment be, or the objection be denied.
okay, let me, Ms. Wright, make sure you understand what's going on here. The case was started against you and Mr. Flagg back in December of 2019. On December 26, 2019, you were personally served with summons and complaint at the same promenade address that you're using in your pleading today. You failed to respond, and on January 24th of 2020, the judgment by default was entered against you. That judgment lives for 10 years. We are still inside of that 10-year period. You have
Okay.
failed to state of, excuse me, don't interrupt me. I'll let you speak without objection. You should give me the same courtesy. The judgment lives for 10 years. We're inside of that 10-year period. You have failed to state a valid objection to garnishment, ma'am. There's no defect in the underlying judgment. You acknowledge that you co-signed on the note. It is a decision of the plaintiff. Which of the two parties, one, both, or the other one, of the parties who co-signed, that they choose to proceed if the obligation is not met. Having failed to state a valid objection to garnishment, your objection to garnishment must be denied. Ma'am, you have an absolute right to appeal my decision. That appeal must be perfected within 21 days today in the Wayne County Circuit Court. Court will send out an order to you both. Thank you both for coming in. We're off the record.
Thank you, Your Honor.
All right, be safe. Thanks for coming in.
Beautiful.
Okay, let's take this off.
St. Martin in the Fields, Neville Mariner with the Symphony number 101. He also this to the end of the catalog of symphonies there, 104 and all. That's the clock symphony. Hear that clock tick tock. Means something moving. Haydn's music on WRCJ-FM. Handel's music is next. I can share that also. And Neville Mariner. And the platinum of St. Martin in the Fields.
Morning, counsel.
Good morning, Your Honor.
Morning, counsel.
Good morning, Judge.
Okay, we have everybody. This is case number 22-200-874. Michael Farr versus Pods Enterprises LLC. Your appearances, please.
Good morning, Your Honor. May it please the court, Jahan Crump Gibson, P73178, appearing on behalf of the plaintiff.
Good morning, Your Honor. Julie Kosevec appearing on behalf of defendant Pods International LLC.
You remember the State Bar of Michigan?
I am, Your Honor.
You probably have a P number.
I do, P50970.
Okay, we were last together on this file on the 29th of March for our initial pretrial. The court opened your written discovery. What has been done in that regard?
Your Honor, both parties have served their first set of discovery requests. Just earlier, or I believe, Julie, you can correct me if I'm wrong, it might have been last Thursday. Opposing counsel did conduct an informal interview, so to speak, not a formal deposition of a witness to the incident that gave rise to the circumstances pled in the complaint. We have recently just exchanged, as of this morning, it's inadmissible, but a settlement offer. So I think we're moving the needle, Judge.
All right, well, let's do this. Let's give you a return date of May 24th at 11 o'clock. Does that work for everybody?
Works for me, Judge.
The defendant, Your Honor.
Okay, we'll continue your written discovery. Now, as you know, in the district court, discovery is either by leave of court or by stipulation of the parties. So if you guys decide between the two of you, you want to take a deposition, you can certainly do that by stipulation. Okay, now,
Very well.
let's see if we can't get this case settled by the next time we're together. It's going to be May 24th at 11. Is there anything else we can accomplish today?
I don't think so, Your Honor.
Anything
No,
from you,
Judge.
counsel? All right, well, let's be safe. Thank you both for coming in.
Thank you. You too,
Thank you,
Judge.
Your
Have a good day.
All right, you too. We're off the record.
Bye-bye.
The Opus 3 works entitled Shared Addressing, the first of the set of addresses, one George Brandon Kendall. Neville Mariner, Academy of Safe Run Fields on WSCJ. I have low fifties today, Metro Detroit zero out of 11 Celsius, upper fifties around 14 Celsius here in southeast Michigan and southern Ontario. For 90.9 WSCJ FM Detroit.
Join us this Saturday, April 29th at the Sullivan Performing Arts Center as Zool Bailey and Victor Santiago Asuncion perform the passionate sonata for cello and piano by Sergei Rachmaninoff. Tickets are available now at 313-335-3300 or online at chambermusicdetroit.org. Our recent spring campaign was one of our shortest pledge drives, and we're so grateful that you showed up to make it a success. If you haven't had a chance to make your investment in great music, you still can. Start a monthly gift at 866-909-9725 or go to donate at WRCJFM.org. Thanks for supporting WRCJ.
14 hours of classical music every day, 10 hours of jazz at night. We are WRCJ FM and HD1 Detroit. WRCJ FM, today's Wednesday, music show, the Trouble Summits. Domenico Scarlatti, Sesquicentennial Sergei, later this 150th birthday anniversary this year here in Rachmaninoff. And we start the album with Mozart from the expert, Mitsuko Uchida's the pianist, playing the piano concerto number 6. Music from the young man, 20-year-old Mozart, Jeffrey Tate and the English Chamber Orchestra, WRCJ FM.
All right, we are on the record calling file 22-192-899. File is entitled National Collegiate Student Loan versus Cheryl Patterson. Your appearance.
Alexander Sarhan, P77252, on behalf of plaintiff.
Mr. Sarhan, have you received any pleadings in response to your motion to reinstate the case?
Response to pleadings, no, Your Honor.
Your motion.
This motion is brought pursuant, of course, 2.612C. This action was commenced on August the 9th of 2022 to collect the balance due and owing on a default student loan. On November 7th, a order for alternate service was granted. The defendant, Cheryl Patterson, was served in accordance to that order. She failed to file an answer, and we have submitted the proof of service was submitted timely. Nonetheless, the default judgment was rejected by the court for the reasons being that a 36th district court officer was not used. However, in the order for alternate service, it did not specify that. But the alternate service order itself was in terms of certified mailing, return receipt, first class mailing, and tacking was complete. So we would ask that the case be, that the dismissal be vacated based on the fact that the alternate service order, based on what we had, was in fact completed with on-time performance.
Sir, are you familiar with Michigan Court Rule 2.106? You have your rules there?
Not directly in front of me, no, Your Honor.
Well, let me refer you to it.
Please.
2.106, this rule governs service of process by publication or posting pursuant to an order under MCR 2.105I. Specifically, paragraph E2, the order must designate who is to post the notice and file proof of posting. Only a person listed in MCR 2.103B1, 2, or 3 may be designated. If you go to MCR 2.103B1, the only people who are in that category, a sheriff or deputy sheriff, bailiff or court officer, an officer of the Department of State Police, a police officer. So the court rule, you asked for alternate service. The rule that you asked for says only certain people can serve it.
Yes, Your Honor. We had it served by a court officer. Went and performed the tacking.
Okay, well, counsel, I'm going to grant your unopposed motion for a different reason. Looking at the register of action, it appears that in regard to defendant Cheryl Patterson only, we sent out a notice of intent to dismiss as to that defendant shortly after the default was denied. So we issued it and dismissed the case as to defendant 2, who is Cheryl Patterson, it looks like, on the same day. January the 18th of 2023. However, when I review the file, there is no SCRA status report as to that defendant. In fact, you don't have one as to either defendant. So you haven't done your job, counsel. So this is what you're going to do. You're going to submit an order granting your motion, unopposed motion, to reinstate the case as to defendant Cheryl Patterson. You're going to submit a proposed default as to that defendant with all of your proof of services. In addition to that, in your proof of services, you're going to have an SCRA status report as to Cheryl Patterson. Got it?
Yes, submit an order as to Cheryl Patterson, proposed default with our proofs of service, and what was the last request?
Service Member Civil Relief Act affidavit, SCRA status report.
Yes,
Okay?
will do, Your Honor. Thank you very much.
Yes, sir. Have a good day.
You as well.
We're off the record.